Thank you, Your Honor. Ladies and gentlemen of the jury, like Mr. Anand and Mr. Gunner, Defendant Mr. Goldigger very much appreciates your service today, your attention to detail, the time that you've spent with us today. At this point, you do have an important job to do, and I'd like to sum up the evidence that you've seen today and help you think of a framework for analyzing the difficult issues before you. First of all, have you ever heard that expression, you can't have your cake and eat it too? Well, with all due respect to Mr. Gunner, that's what he's doing here. And he's doing it in two different ways. First of all, he told the patent office, in order to get the patent, my invention is a seatbelt, and my invention allows movement of the torso. And yet, he's coming today before you and saying, my invention covers a product like a roller coaster harness that doesn't allow reasonable movement of the torso. He can't have his cake and eat it too. He convinced the patent office to issue a patent by saying it's a seatbelt and it allows reasonable movement. Now, the second way that Mr. Gunner is trying to have his cake and eat it too is what the claims cover. He wants the claims to cover a roller coaster type harness so that there's infringement, right? But if the claims cover a roller coaster type infringement, then there's invalidity. That was in the prior art. Now let's talk about the court's claim construction of the passenger restraining system. The court said, and you must follow in your deliberations as you discuss the evidence today, you must follow the court's construction. The court said that the claim term passenger restraining system means that it allows a reasonable amount of movement of the torso and arms. Now, have any of you ever been on a roller coaster and had one of those harnesses pulled down over your shoulders? That's one of the beauties of our judicial system. Our jury system here in the United States allows you, the jury, to bring your personal experience to the resolution of the question before you. You can think about the times that you've been on a roller coaster and whether or not you were allowed reasonable movement of your torso when that harness was down. Think about that as you deliberate about whether or not the accused rejector system has a restraint as required by the court's construction. Now, another way that you get to bring your own personal experiences to the question before you today is on the question of obviousness. You have to decide whether Mr. Gunner's invention is obvious. Now, you have a piece of information that the Patent Office did not have when it decided to issue Mr. Gunner's 007 patent. In particular, the seatbelt patent, the 917 golf cart patent, the ejector seat that meets every single limitation of the claims was not before the office. You have better information than the Patent Office did. Now, if you're trying to solve a problem of making an ejector seat for a spy car, isn't it obvious? Doesn't it make common sense to add a passenger restraining system? You can use your common sense. Is this the type of invention that you want our patent system to protect? It's in your control to say, no, this is not the type of invention, this teeny tiny advance of adding a seatbelt to a passenger ejection system that had already existed in the art is the type of advance that we want our patent system to protect. I ask you to consider Professor Gadget's testimony that such minor advancement is obvious and the patent should be invalidated. Now, one final point before I sit down is what Mr. Gunner's counsel referred to as objective evidence of non-obviousness. Dr. Benz said that Mr. Gunner's ejector seat, the easy ejector, has had a lot of sales. The one thing that Your Honor, Judge Syme, is going to explain to you when he gives you the jury charge is that commercial success is not adequate to defeat a charge of obviousness when there's no nexus. Now, that's a legal term, but what that means is that commercial success has to be tied to the claimed invention. Now, Mr. Gunner's counsel and nor Dr. Benz provided any evidence to show that that commercial success wasn't for some other reason other than the invention. Use your wild imagination. It could be because the thing is priced cheaply. It could be because Mr. Gunner pays a lot of money to advertise. And because there's no testimony that shows a nexus between those commercial sales and the invention, what's claimed